Hi, I'm Kris Kobach, and I'm a professor of constitutional law at the University of Missouri in Kansas City. And this presentation is about a resolution that is currently before the Kansas Senate, SCR, that is Senate Concurrent Resolution 1626. Now, this decision has to be taken in historical context, this decision whether to create a constitutional right like this. And I am in favor of passing a SCR 1626. The context is this. When our Constitution was framed, the framers, the Founding Fathers, they were very clear in pointing out that the powers given to the states were very broad, and the powers given to the federal government are very narrow, and they are expressly defined in the U.S. Constitution. And in defending this Constitution, in Federalist number 45, James Madison was trying to reassure people who were skeptical about the new Constitution, the proposed Constitution. And he said this: "The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. The powers reserved to the several states will extend to all the objects which in the ordinary course of affairs concern the lives, liberties, and properties of the people, and the internal order, improvement, and prosperity of the state." End quote. So in that context, we have to realize that the ability for a state to create new constitutional rights flows from its broad powers, which are commonly referred to as a state's police powers, the power to do things that protect the health, safety, welfare, and morality of the people of the state. Congress has no such police powers. Congress only has the enumerated powers listed principally in Article 1, Section 8 of the U.S. Constitution. And with that in mind, then we now turn to the current health care debate in the U.S. Congress. The health care bills that at the time of this filming are currently pending before the Congress include two different bills in the House and Senate, each passed by its own House respectively. And those bills both include an individual mandate, a mandate that every American, with a few exceptions, but that most all Americans must purchase health insurance. Now, this is unprecedented. Never before has Congress attempted to force Americans to purchase anything, period. This is a totally new exercise of power. Now, Congress is attempting to exercise this power through the Interstate Commerce Clause of Article 1, Section 8, which gives Congress the authority to regulate commerce between the states. But no Supreme Court iteration of what the commerce power allows Congress to do comes close to expressing an open door for Congress to do this. The closest examples we have are from the decision of the Raich case of Gonzalez versus Raich in 2005, and here's a quote from it. "The question is whether Congress is regulating activities that substantially affect interstate commerce or activities that are, quote, part of an economic class of activities that have a substantial effect on interstate commerce," end quote. Now, a lot has been done on the basis of the commerce power. Congress regulates all sorts of things on the theory that some tenuous connection through a series of events will eventually produce an effect on interstate commerce. But in this case, what Congress is attempting to regulate is inactivity. They're attempting to regulate people who are not engaged in commerce, who choose not to enter into a contract with an insurance provider to purchase health insurance. And they're attempting to regulate inactivity, and the things that these people are doing who don't purchase health insurance are not of a commercial nature. In other words, they're not engaging in commercial activity in their decision to remain inactive. And so it would go beyond what the Raich decision supposes is the precondition for congressional action, that they must at least be regulating an economic activity that in turn has a substantial effect on interstate commerce. So that's why the individual mandate is on shaky constitutional footing in these two bills before Congress. Now, you might be saying, well, wait a minute, Kris. The Congress has the authority to pass a law, and when Congress passes a federal law, that statute trumps any state constitutional provision because federal law is supreme according to the Supremacy Clause of the U.S. Constitution, and that is true. But an unconstitutional federal statute does not have preemptive effect or does not displace any countervailing state law or state constitutional provision. And that, of course, is a decision that will ultimately be adjudicated by the Supreme Court, I'm confident. Because this is such an unprecedented act that Congress is attempting to achieve, if it passes, there will undoubtedly be a challenge that this far exceeds Congress's commerce power. And it will probably be a close question in the U.S. Supreme Court as to which way it goes. But the passage of the Kansas Healthcare Freedom Amendment would actually make a difference and better protect the rights of individual Kansans not to be forced into that insurance marketplace if they choose not to be forced into that marketplace. And the reason is this. First of all, it articulates a state constitutional right. So when the case comes before the Supreme Court, it's not just one individual's opinion that Congress is exceeding its commerce power, interstate commerce power, but it's the opinion of the collective people of Kansas that we have enacted a constitutional amendment that is defining our liberty in this area, and we wish to preserve this liberty in the Kansas Constitution. Although that doesn't change the analysis, the legal analysis that the Supreme Court engages in, it does change the atmosphere. Now it's not just one person arguing against the court, it's the collective judgment of the people of Kansas that this ought to be a state constitutional right. The second is an even more important effect that SCR 1626 would have, and that is that it would give the state a basis to intervene in the case. Now, the state can always write what are called amicus briefs. Amicus briefs are when parties, or individuals outside of the parties before the court, want to express an opinion and try to persuade the court. They write these briefs called amicus briefs, friends of the court, amicus curiae briefs, that will just offer their opinion. But if the state of Kansas could intervene and join the case as a party standing before the court, that would place this argument on stronger footing. And the constitutional amendment would give Kansas potentially standing to intervene in the case. And I say potentially because it depends on how the case arises, who the individual is that's challenging the individual mandate. And there is a possibility that the court would say Kansas as a state, and that would mean the Attorney General's office, has the authority to intervene on behalf of the people of Kansas whose constitutional right is being injured, in fact, by this federal act. And that's a lot of legal jargon for what it takes to have standing in a case. It's not a slam dunk, but there's a good chance that this Kansas constitutional amendment would give the state standing to stand alongside the individual in that case and bring the resources of the state Attorney General's office to bear. The third reason is probably the most important, and that is it invokes the plain statement rule. If we pass SCR 1626 and the people of Kansas adopt it, then we have a state constitutional provision standing in opposition to an act of Congress. And the Supreme Court has said, going back to the precedent of Gregory versus Ashcroft, the Supreme Court has said when you have a state constitutional provision at issue and a federal statute at issue and federal-state sovereign relations are in the balance, then we are going to require Congress to make a plain statement that it intends to displace the sovereignty of the states. What that means in practical terms is if there's any ambiguity in the act of Congress, it has to be interpreted in favor of state sovereignty, in favor of the state's sovereign interests. So there may be some ambiguity in the bill that ultimately comes out of Congress if a bill is passed. And that ambiguity in the bill would have to be interpreted in favor of states' rights, in favor of the sovereign authority of the state of Kansas. That's another consideration that would be affected by the passage of 1626. So those are three reasons why we need a statement in our Kansas Constitution that says you as a Kansan have a right to not purchase health insurance if you choose not to purchase health insurance, that you have a right as an individual to freely contract in the area of your health, whether it be health care or health insurance. And that's why it is so important that the Kansas legislature act on SCR 1626. Thanks.